The Gauteng High Court in Johannesburg has dismissed the uMkhonto Sizwe political party's bid to seek a declaratory alternative, an interdict, which would have halted the imminent Judicial Services Commission's sittings that start on Monday. The party turned to the High Court in an urgent application, which was heard on Friday, the 4th of October, after its request to the Judicial Services Commission to postpone the sitting pending the finalisation of the review of Dr. Hlophe's designation to the Commission was not acceded to. The MK sought declaratory relief, which would have invalidated the Judicial Services Commission's decision, alternatively an interdict which would have halted the sitting. Judge Stuart Wilson, in a judgment delivered electronically, was faced with determining whether the JSC acted rationally in light of the fact that the full bench, Western Cape High Court judges, had barred Dr. Hlophe in an interim relief from participating in the Judicial Services Commission. Judge Wilson concluded that the Commission acted rationally in refusing to postpone its October 2024 sittings, adding that his decision did not infringe on the MK party or Dr. Hlophe's rights. Judge Wilson further found that, assuming in the applicant's favour that their constitutional rights have been limited, the source of any such limitation was the full court's order, not the JSC's conduct in light that order. In the implications of this, the judgment is that the JSC will continue its interviews as scheduled on Monday, the 7th of October 2024. Let's unpack this with researcher at Judges Matter, Mbekezeli Benjamin. Mbekezeli, thank you so much for your time this afternoon. Really do appreciate it. Well, this is the outcome. This was, of course, an interdict application, or at least a part of it was an interdict application alternative to a setting aside review order. That means on Monday, the JSC will go ahead. Between today and Monday, does the MK party have the option of urgently approaching a higher court or a full bench in the High Court or the Supreme Court of Appeal to review this interdict outcome? Of course, interdict outcomes are not typically reviewable, especially interim interdict outcomes, given the high threshold there. But there's a slight chance, wouldn't there be?
Good afternoon, Oliver, and good afternoon to the viewers. That's a long question, but essentially the answer is that there is no option between now and Monday for MK party to take further legal action that will enable Dr. Hlophe to participate in the interviews that are scheduled for the next 2 weeks. So today's judgment essentially spells out what the Western Cape High Court judgment of last week said, is that at this moment, Dr. Hlophe's eligibility to be on the Judicial Service Commission is under question. And what the Western Cape High Court found was that the DA had made a plausible case that the Parliament's decision to designate him as a member of the JSC may be reviewable or is subject to some question mark. And so in the meantime, Dr. Hlophe may not participate in the interviews. And what the court today said is that the JSC's decision to go ahead and not postpone the interviews was in line with that decision by the Western Cape High Court, and the JSC had acted rationally considering the law and the practicalities of postponing the JSC interviews.
Yep. So given that there's very little legal remedy for an appeal process in the interim, or at least between now and Monday, for an appeal of the rejection that they had received today, one has to ask the question, will Monday's proceedings or the next 2 weeks' proceedings of questions be a reviewable process at the end of it all, should the court ultimately find that, hey, Dr. Hlophe is actually eligible to serve on the Judicial Services Commission?
No, it is not reviewable, because the case law up to this point on the composition of the JSC is that all members of the JSC must be present for the JSC to be properly composed. The only reason that a member may not be present is for a legitimate reason. And so if a member is absent for a legitimate reason, like a court order, for example, then the JSC can continue ahead, and any decisions that are taken, any questions that are asked, any candidates that are recommended from that process, those recommendations are legitimate and lawful. And so later on, even if in the end Dr. Hlophe and the MK party succeed in or defeat the DA's court application, the interviews that will happen in the next 2 weeks will be properly lawful. There's no scope for them to be challenged or reversed.
Yeah. Yesterday, the MK was given a date by the Western Cape High Court on leave to appeal for the Part A of the application, which is the interim relief that was granted to the Democratic Alliance, barring Dr. Hlophe from participating. That will be heard on the 1st of November, according to the MK party. Now, given that that will take place after the next 2 weeks where interviews will be taking place, will there still be meat left on that case, or will it be a moot case, given that between now and the next set of interviews, which is only in April next year, the main application, which is Part B, would likely have been heard and decided upon?
Well, let's take a step back a little bit, Oliver. The Western Cape High Court's decision was an interim interdict. So what it means is that temporarily, Dr. Hlophe may not participate in the JSC proceedings, even though he is still a member of the JSC. And so what the MK party is appealing on the 1st of November will be that temporary order that bars his participation, right? And so if they, in the end, succeed, for example, and say that that temporary interdict should not have been in place, then it will simply mean that the sort of boat has already gone. The train has left the station, because by that time, the interviews would have been concluded. And so essentially, the point would be moot. It wouldn't have any practical reality, and which is why it is probably better for the MK party to focus on Part B of the application, which really deals with whether the National Assembly's decision to designate Dr. Hlophe as a member of the JSC was lawful in the first place. In all the judgments that have come out so far, both the Western Cape High Court judgment and today's Johannesburg High Court judgment says that that question is open to some doubt. The MK party may win, the DA may win. We don't know at this stage. But that is exactly what the MK party, I think, should be focused on, because what the interdict means for now is that Dr. Hlophe cannot participate in any of the proceedings until those proceedings are concluded, the court proceedings are concluded. That means he will miss these interviews in October, and he might miss the interviews that are happening 6 months from now in April of next year.
And does that not meet the threshold of prejudice, given that the court may well find in his favor at the end of it all, and he would have missed these opportunities to make a contribution to the JSC? Yes, the High Court in the Western Cape did say the MK party may designate any other member of their bench, but surely it is sacrosanct the party's ability to designate their caucus members to whichever parliamentary function they see fit, as they have done in this instance with Dr. Hlophe.
Well, firstly, let's again take a step back, Oliver. Firstly, to designate a member of parliament to a commission like the Judicial Service Commission and the Magistrates Commission is not like putting a member of parliament to any committee within parliament. And in fact, not all members of parliament can participate in all the committees of parliament. If you fail a securities test, for example, you can't be a member of the Defense Committee or the Intelligence Committee of Parliament. So on principle, I think that part must be clear. So the Judicial Service Commission is
in fairness, no one has yet argued that in court, correct?
No. No one has argued, and that's the point that I'm making now, is that the Judicial Service Commission is a special designation, and that is what the Western Cape High Court said last week, is that the Parliament must apply its mind and cannot simply accept the decisions or the elections of the political parties. It can't just rubber stamp the findings or the recommendations of political parties. Parliament as a body must do more. And so in this case, the MK party's designation or recommendation of Dr. Hlophe and the National Assembly's designation of him on the JSC still remain. He is a member of the Judicial Service Commission. All the court order says that he may not participate. And the consequence of that is that the MK party can't designate someone else, because that seat is already taken, unless the National Assembly recalls Dr. Hlophe, and only then will the seat be open. Or alternatively, if the courts say no, he shouldn't have been designated in the first place. So what that practically means is that yes, Dr. Hlophe is a member of the JSC until the court decides otherwise. He may not participate, but that participation already the court, Western Cape High Court said, is subject to some questions. If he does participate in this round, then there might be consequences for the JSC interviews, and the court said that risk is far too great.
I'm out of time, so a yes or no answer on this. Is there prejudice should the court find in his favor eventually?
No.
Okay.
I don't think there is.
We're going to have to leave it there. Mbekezeli, thank you so much for your time. Really do appreciate it. Mbekezeli Benjamin is a researcher at Judges Matter.